everyone again to day 2 of our Arbitration and Investment Summit. Our panel discussion topic this morning is drafting arbitral awards and mediation settlement agreements. A very practical and essential topic because at the end of the day, what everyone wants to know is what's going in the award and how can we make sure that the award is where it needs to be. We are delighted to have with us 2 leaders in the field. We have Datuk Professor Sundra Rajoo. Among his many accolades, he's the founding president, the Asian Institute of Alternate Dispute Resolution 2018 to date. He's a certified international AIADR practitioner, a chartered arbitrator, advocate and solicitor, architect and town planner. He has authored, co-authored, and edited several books and contributed chapters and articles on arbitration, contract, and construction law, including Arbitral Model Law and Arbitration Rules, the Arbitration Act 2005, amended 2011, 2019, and 2018, and the AIAC Arbitration Rules 2018-2019 by Sweet and Maxwell, among others. Also, we have Dr. Christopher Malcolm. Among his many accolades, he's consultant, senior legal advisor to the Ministry of Justice in Jamaica, and a dispute management practitioner who has been admitted to practice law in Jamaica, the British Virgin Islands, Dominica, St. Lucia, and Belize. His primary areas of focus are banking and finance, arbitration and alternative dispute resolution, construction, real estate, corporate, commercial, trade and investment, regional integration, and economic development. He is a former Attorney General of the British Virgin Islands, a director of the Mona Law Institute's unit, senior lecturer, Faculty of Law at Mona, University of West Indies. He is a fellow of the Chartered Institute of Arbitrators, a former chair of the Chartered Institute of Arbitrators Caribbean branch. He has represented both public and private sector persons and entities from across the Caribbean region and beyond. Gentlemen, thank you so much for agreeing to be on our panel this morning. So, arbitration and mediation settlement agreements. I guess, Sundra, if we could start our conversation with you, what would you say are some of the best practices in virtual hearings to reduce the likelihood of a challenge to an arbitral award under the notion of due process?
Thank you, Colin. Very good morning to everyone. It's a pleasure to be, although we are not in Bahamas, but it's a pleasure to be with you. You know, Bahamas is fantastic. The last trip that I made there, I met up with all our friends, but nevertheless, thank you for inviting me. It's very good to be with my colleague, who's also on the governing council, Christopher of the AIADR. Starting off, is one of the things that has happened with the pandemic is we have been locked down. Basically, we have been in our offices or at home. So there is very little we can do about it except improvise and innovate. And one of the difficulties where arbitration is concerned is basically hearings, because we are so used to having in-person hearings, just like the courts. In fact, in Malaysia, the courts did shut down and have continued to shut down from time to time until they have now come out with a virtual hearing protocol. So they are continuing, but there is a certain level of resistance. And I suspect the same thing is happening in arbitration. So in arbitration, in my own practice, I realize where international arbitration is concerned, that means parties and councils are coming and arbitrators are coming from different jurisdictions located in different areas, there is no option but to do a virtual hearing. Whereas if you are in the same jurisdiction, let's say if you're in Bahamas, you somehow have this hope, like just in Malaysia, and if you're in Kuala Lumpur, a city of 2 million people, and you basically hope that you can have an in-person hearing. So the reluctance is always there. But I think in international arbitration, the switch has been fast. In domestic arbitration, it is starting to happen. It is going to happen as people find it more efficacious. The first thing is that we see this shift to virtual hearings. The second, you find that all the arbitral institutions, including the arbitrators and the parties, are doing all their processes online. There is very little paper now flying around in hard copy. You may hardly see hard copies going around. In fact, I don't send out letters in hard copy except for the original letter that I signed. And even that is scanned and sent, and then a copy is sent by post. So I think there is an increase of e-filings, there's an encouragement of video conferencing, virtual and all these things. It is now very, very common to have actually meetings, virtual meetings for preliminary meetings. Now, the real problem comes up with is how do you make sure you follow this word called due process, right to a fair hearing, and also the other requirement under normally all the arbitral legislation that parties should be treated equally, right to equal treatment. I think under the New York Convention is Article 5.1, whereas that is for giving proper notice, that you must give proper notice. An award will be set aside if you don't get proper notice. If you're unable to present your case, or the procedure is not according to the agreement, or such agreement that changes the procedure is not in according to the law of the seat. So I think, because of that, arbitrators, parties, councils, everyone who participates, institutions, should be well aware on how to make sure these elements under the New York Convention, which is actually replicated in the national legislations, not to contravene them. Now, the first problem basically comes up with, in all hearings, especially under a common law system, adversarial system, there is an emphasis on oral evidence. I think it's less in the inquisitorial system, more the civil law. But I think in arbitration is sort of harmonizing and it's coming to some kind of balance. There is still some oral evidence. And this oral evidence needs to be assessed. And the arbitrator's ability to assess that oral evidence in a virtual hearing becomes an issue mainly because of connectivity, sometimes quality of the sound or the video. He cannot see the demeanor of the witness. He cannot see the body language of the witness. I mean, parties may feel that this is not very clear. Again, I think, that it all goes back to the credibility of the evidence. So this is one of the issues. How do you overcome that issue? In actual fact, is to prepare. What you have to do is do thorough preparation. Maybe the parties and the council should, and the arbitrators, not the arbitrators, but the councils should have a pre-trial session to test out the virtual hearing so that it is stable and assist in the management of the hearings. Of course, when we have oral evidence, there is always this issue of witness coaching. If somebody is in the room, I remember, when we all first, before the pandemic started, video conferencing, a video examination of witnesses through video conferencing was a novelty. In fact, there was papers written about it, and it was the exception rather than the norm. And it was always this worry about how witnesses are going to give evidence and whether there will be coaching. Coaching is basically about whether the witness is being secretly advised by some device, because if you are in a hearing, you can see everything. I've caught people, or the other thing is reading from a document. So it's where I in fact I just completed a hearing last year where in a re-examination the witness was reading prepared text. So I think I noticed it. I say, what are you reading? But if it may be more difficult to do if you're actually looking from a distance like this. I don't know what you're doing below your legs, Colin, but I'm sure they're okay. But nevertheless, that is the actual situation. So how do you come this? I think, basically is that, I just sat in an international arbitration too, where we had virtual hearings, and the chairman, the presiding arbitrator said, can we have a look at the room? Can you please scan the room? So the witness has to actually, he's alone and he scans the room. Of course, if you have a wider screen arrangement, then you can see everything, you see. So I think that is the one way of coming up. Now, the real problem where we international arbitrators have is the uneven technology. In certain jurisdictions, the connection is stable. In other jurisdiction, the connection drops. And and then sometimes you can't say I was sitting in a Paris arbitration, the chairman was dropping. So you can't say it's only the developing or emerging countries are having problem. It's just a connection problem.
Right.
I think you have to look at that. And you have to deal with it. I think you have to have some protocols to make sure that this is the standard, this is the width band, and all these things have to be done. And there's a cost and benefit to it, but I think sometimes the cost has to be paid so that everybody has an even platform. I mean, some respondents or some parties who are reluctant to come in may wish the line to drop. So you have to take you can't draw a complete adverse inference. I think that's one of the more difficult things in a virtual hearing. But I think you have to actually balance the thing. But again, it comes back to preparation. You have to set it right and tell them this is what is expected. Sometimes you have a backup system. I have one chair which basically says that you must have a 4G phone next. And so that we can call you, with this line, and these are the numbers that you can call and all these things. So she's very efficient. So it's quite remarkable to see such kind of people creating these rules as they learn from what they do quite quickly. The third thing is that in most it is virtually impossible to do note-taking, the traditional note-taking in virtual hearings. You will find that it doesn't really work, because it's not very efficient. The traditional way of, sitting in the court and then you take notes and then you look up and say, what did you say? Please repeat. And I take down, everybody watch my pen. All that doesn't work anymore. Now it's a transcript. So service providers come in, there are interpreters, there are transcribers. So, okay, this is another problem, which actually is the reality. We all don't speak the same language. When I say we speak English, actually we don't really speak English as English because we speak with different accents. And a person from Africa, a person from America, a person from Europe, a person from China will have a different accent, a person from India. So there could be a problem in transcribing, It depends who is transcribing. You must be actually attuned to that accent. Although you're recording it, you may also have a problem. So I think that is interpreters, of course, interpreters, that there could be a problem if the interpreter, which I think is a common thing, because I remember, in China, the first time I sat in a CTEC arbitration, and we had simultaneous translation, and I was assigned an interpreter because the language of the arbitration was in Chinese, and the interpreter assured me that he is an honest interpreter. He interprets the truth. and he will tell you the right thing. So he will not do anything ambiguous or tell you untruth. He will interpret what is exactly. So, I mean, it's quite interesting, you know, when I heard that, I said, oh yeah, there is actually another layer that you have to deal with as an arbitrator. Now, the last point that I want to make on this thing is actually the security problem, cyber security problem. If someone wants to hack in, I think in very, very large arbitrations, people may want to know because of the confidentiality arrangement, or they may want to disrupt. So you may have to actually put in some security arrangement. And that is why it's so important to go to a service provider who is actually experienced and well arranged. You know, so I think, you know, you just cannot actually say, I will take somebody local and do it like that, where the disputed amounts and the stakes are very high. It is better to actually have the right cyber security arrangements. So I think the responsibility of an arbitrator in such a situation is to actually manage the hearings, virtual hearings, to balance the needs of the parties. I think also to make sure that the issue of due process, parties are given a fair hearing and treated equally. And I think towards that end, we have seen a number of institutions coming out with protocols. It's very useful, you know, look at the Seoul Protocol, look at the ICC Protocol, the CR Protocol, the Hong Kong International Arbitration Center Protocol. So I think that is what I have to say about virtual hearings. I hope I've covered everything. That's what I think is required, but I can talk anecdotally about some of the things that I'm going through, but that we can do later. Thank you, Colin.
Great. Well, thank you very much for that very informative checklist of things you would want to consider to help reduce the likelihood of a challenge. Thank you very much. Chris, if we could ask you, and just before, if our audience have any questions, please feel free to put them in the question and answer box. And when we're coming towards the end, we'll try and address those for you. But Chris, what would you consider to be the key ingredients of a good settlement agreement in mediation?
Thank you, Colin. Good morning again to Colin, to my friend Sundra and council member at AIADR, and also to all your listeners and followers on this webinar. Before I get there, there's one thing I wish to quickly highlight based on what Sundra has said. It is true that the institutions globally are making adjustments coming out of this COVID period. And I think we have to be careful because some of them, in my view, may be making adjustments which are in the nature of capturing benefits or perceived benefits that persons may have thought they had in the nature of how they entered their agreement. So for example, the LCIA, with their new rules that came into effect on the 1st of October 2020, have a provision in it to the effect that regardless of what the seat of the arbitration is, if there are arbitrations that commenced after October 1, and there are challenges or any questions to be dealt with in relation to the interpretation of the LCIA rules and so on, those are to be dealt with in the English courts by reference to the law of England, which may or may not reflect the benefits that parties may have had for themselves, which is that we have chosen a seat of an arbitration, including because we want to ensure that procedural and related matters, including by reference to the interpretation of rules, are done in a manner which is consistent with ordinary contract law principles, providing that rules are subject to, contracts generally are subject to interpretation by reference to applicable law. And the applicable law would ordinarily be the law that the parties have agreed under their contract. So we are seeing these things, and I think we have to be careful as this pandemic continues and other periods of crises, that we don't see a whittling away of what would be considered generally accepted proper contract principles. And I think parties, in my view, have to now seriously reconsider when they're looking at the LCIA or any other institution, whether or not they are, without thinking, entering into agreements which may be depriving them of benefits that they thought they may have had, or benefits that they think they should be entitled to. So that is one of the things I would say there. Now, getting to the question that you've asked me specifically, what are some of the things that you have to consider in drafting proper settlement agreements? I think it depends on the perspective from which you're sitting. If you're sitting as counsel, there are one set of considerations to be had. If you're sitting as mediator, there are another set of conditions. So let us start firstly with sitting as counselor, as a lawyer, assisting or advising anyone. The basic position to bear in mind is that you must have a clear idea of what your end game is, knowing that a mediation settlement agreement is one which, when entered, should be one capable of being enforced as a contract. So with that in mind, the general applicable principles of contract must be there. You must ensure that there's clarity as to who the parties are. You must ensure that there's clarity as to what the subject matter of that agreement is. And notwithstanding, for example, that the dispute may involve A, B, C, and D items, it is possible that insofar as a settlement agreement is concerned, the parties only wanted to cover items A and B or A and D. So you have to be careful that the settlement agreement, when determined, is clear as to subject matter. And these are, of course, general contract principles. You also have to be clear that the agreement is capable of being enforced by reference to the general principles relating to consideration, intention to create legal relations, and so on. Because at the end of the day, if not voluntarily complied with, any agreement that is entered will only be able to take effect by reference to whether or not it upholds generally and accepted principles of contract law. So that's one of the things you have to bear in mind. So with that in mind then, counsel must ensure that agreements that are entered one, by parties who have the capacity to enter into those agreements. And it is something we have seen it at all times, or those of us who have done work in the mediation space would have had instances or possibly had instances where you have, for example, a company being represented and appropriate measures are not taken to find out that the person actually in the mediation is somebody who has relevant authority to bind a company. And so you may go through a process and find that you could have difficulty being able to establish that the person had real or even properly considered apparent authority to enter into the agreement that was entered. So that is something you want to be very careful about. And as I said earlier, the subject matter is something that you be there about. So where counsel is involved, to that extent, you must be careful to ensure that you capture what the parties actually need and that the agreement when entered is entered to reflect their needs, what they have agreed, and not what you think is what you would want to have there included, because otherwise you will not effectively bring about a settlement, because what you would then be doing is giving effect to your own desires rather than the proper desires of the parties who are requiring that agreement. If it is, on the other hand, that you're sitting as mediator, your first thing to remember is that you're there to facilitate or enable a process, and that it is not for you to draft an agreement or to determine an agreement for the parties. You will give guidance. You will ensure that the parties are directed in a way that can help them to resolve the issues. But it is not for you to take on the role of preparing that agreement. But what then would the mediator have to do? The mediator then has to ensure, of course, that if you're giving guidance, it is guidance well considered. It is guidance having regard to what you've heard, and it is guidance being done. And while it is true, and let me depart a bit, to say that the mediator is not there to draft or settle agreements for persons. It is also true that as mediator, you're chosen because the parties are prepared to repose confidence in you to assist them. And to that extent, you have a significant amount of sway, moral or other, through moral suasion or otherwise, that you can bring to bear on the process to guide the parties effectively to an agreement. And there are ways in substance to get parties to agree what you think they should agree, and ensure at the end that it appears as coming from them, because that is what is critical. The agreement must be theirs, not yours. So those are some of the things that you want to bear in mind, and to ensure at all times, as I say, that you know what the end result is that is wanted, that you are clear what the parties are about, and that you're clear that whether you're guiding the process as a mediator or you're actively involved in the drafting of it as counsel, that you do so bearing in mind that what you are about is ensuring that the parties themselves are comfortable, and to the extent possible, that it resolves all, to the extent possible, of course, the disputes that are before you and what is being considered and sometimes, as well as you're going through that process, the parties may come to you with A, B, and C, and you recognize that for them to have a holistic resolution, they may also need to consider D. So to the extent that you're able to influence that decision making, it is important to be able to do that as well. Thank you very much.
Yes. Thank you very much for those very detailed considerations, Chris. Sundra, if we can go back to you for a moment. Can an arbitrator or tribunal proceed with the arbitral proceeding if the respondent refuses to participate in a virtual hearing?
This is a default by the respondent. So I suppose the usual rules apply. It's subject to the agreement of the parties. You know, if the parties have agreed that there will be a hearing and that has been directed, then the respondent is also bound to come for the hearing. But I think the most important thing is you need to actually ask the respondent why the respondent has not actually attended the virtual meeting. See, I think that would be the first thing. You cannot assume that the respondent is willfully refusing to attend. If it's willful, then it's a different way of dealing with it. There could be some genuine reasons why the respondent is not coming for it could be that connection is not on, or they say that, look, you know, I'm trying to connect, but it's not happening. I'm trying, you know, we had a situation recently in international arbitration where the respondent, we all were waiting, the respondent doesn't come on, then the chair calls the respondent and the respondent doesn't pick up. In the meanwhile, the respondent sends a message and says, look, I'm trying to connect and I cannot connect. So I think you have to take it in good faith.
Right, right.
I mean, at first glance, you must not, as an arbitrator or arbitral tribunal, form any view, but you should take a view that, look, there is some difficulties, but I think the important thing is to actually give another opportunity. There will be wasted costs in this instance because you know, virtual hearing costs money and parties are there. It's just like a normal hearing. People are waiting. Witnesses are there. Sometimes, you know, if respondent doesn't turn up, that means there is no cross-examination. So, you know, let's say the claimant is ready to go. But normally, what the arbitral tribunal will do, and it depends again, you know, what are you having? Are you using institutional rules? So you must know the institutional rules, or are you using, let's say, an arbitral law of that jurisdiction? So you also must know what it allows you to do if a respondent defaults. And normally both have provisions for defaults. And it will require, first thing is that to ask the respondent that to tell the respondent you have defaulted, you have not actually attended the meeting. This notice has been actually conveyed to you, or you have agreed to this hearing that is going on. It's supposed to happen at this time and this time. As we locked in at that time, you did not turn up. We waited for you as usual. And normally that notice will go out as a peremptory order. a peremptory notice. I mean, some people call it order. I call it direction. Maybe it's just a notification to the respondent. Look, this is a serious matter. You did not turn up. Can you please give your explanation? We are now going to set another date.
Right.
Of course, there is liberty to apply, and then we will set another date where actually, because the claimant was there, you would have asked the claimant what dates are you available, and you said, but you have no opportunity to ask the respondent. So you set the dates and say that on this date, we will again reconvene by virtually having that hearing, and then basically see whether the respondent turns up again or refuses to attend, refuses to participate. Refusal to participate has to be expressed in the sense that there is, I think many respondents say, I do not recognize, I do not come, then it's quite easy. Many respondents will also keep silent, or others may come up with some excuses that they are very, very keen to attend, but unfortunately they cannot join in. But I think you have to actually evaluate what the reason is, give them an opportunity to attend, and then move on to the next stage. The next stage basically is that you start the hearing again, and at this hearing, you cannot, I normally will do it twice, First, I will let it go. The second time depends on what the reasons are. I may let it go, but normally I don't. I'll just go on. I'll go on, and then I will actually ask the claimant to present its case. But of course, the respondent is already told earlier that if you do not turn out, we will go ahead with the hearing as if you have consented to it. Unless you have presented some kind of objection before that, before the hearing. So on that day, if nothing happens, we will just carry on. But then the claimant must present its case, must present all its evidence. The arbitral tribunal may ask questions because there is no questions being asked by the respondent. So to test the evidence, and then the arbitral tribunal will have to go through each witness through the same process, administering the affirmation or oath, and then going through the examining in chief, then standing down for cross-examination, and then the arbitral tribunal ask, and then allow a re-examination, and then keep a set of notes of the proceedings. So when the proceedings end, that set of notes is actually shared to both parties and the arbitral tribunal. And after which, the arbitral tribunal will also set directions for submissions. Again, opportunity is given to the respondent to provide its submissions. So I think, basically at the end of it, due process is followed. A certain level of what we say is equality has been achieved. You have taken evidence the best you can. You must, actually, the arbitral tribunal also must be very, very careful of how it communicates its directions, the way because you have a transcript, what it says in the hearing. It must be very measured, it must be very careful, and it must be mindful to provide a very clear process for communication. And then it also must apply the proper burden of proof, standard of proof, and then come through its decision. So, and I think the arbitrator must be always mindful, or the tribunal must be always mindful, that the non-participating respondent is notified of every step, every part of the procedure that has been followed, and every correspondence is copied. So all communication between the claimant and the tribunal must be communicated to the respondent. And then the respondent is also given the notice. I think both parties are given the notice when the award is going to be made, and the intention that the arbitral tribunal is proceeding to a final award. And then once that award is ready, parties are notified. So I think that is basically following the rule of due process and natural justice. So I think other than that, it is quite frustrating hearing one side, I must tell you that, and not having the other. And of course, I think no arbitrator should try to improve representation or be a advocate for any other party. So I think it just, you stand in and you just look at whatever is available before you and make a decision the best you can. That's the job that we have. Thank you so much.
Thank you very much for that, Sundra. Chris, I know we have a few moments left, but if I could just get your views, please, on, particularly with regard to COVID-19, how can settlement agreements and mediation best be leveraged in times of crisis, such as the COVID-19 situation we are facing today?
Well, there was a time up to recently when we all considered arbitration to be sexy. I know I heard Robert earlier, and he has been speaking about adjudication and the perceived benefits of adjudication over arbitration. But I think what has been coming through very clearly is the extent to which mediation is perhaps even more suited for times of crises such as this than arbitration, litigation and adjudication and those other more adversarial processes. And the reason for this is that we all recognize that we are in a position where we're all suffering. And so what we're concerned about is how we're able to distribute losses. We're all losing. And what mediation does is that it, in a better way, allows for the parties to engage in constructive decision, enabled and supported and facilitated by a mediator, who can then, as mediation, those of us in the mediation space know, the essential benefit of mediation is to help to direct parties away from positions, established positions, to areas of mutual interest based on which they can hopefully arrive at an agreement that will resolve their dispute. So what mediation is doing then and capable of doing, and is being increasingly relied upon right now, is to get the parties to a space where they can speak, where somebody can, in and out of quotes, knock good sense into their heads to say, fellas, you're all on a losing path anyway. Let us see how we can minimize those losses. Let us see how we can better distribute them. Let us see how we can maintain relationships. Let us see how we can move forward in a situation where we don't have to be chopping off each other's heads. Let us move forward in a way where we don't have to go about boasting about or speaking about the value of the significant arbitration awards or litigation orders, judgments that we have received and so on. But instead think about how it is that we can constructively come up with new and more progressive settlement arrangements that can help us to move forward in a way where we preserve our relationships and we enable the parties to continue to do what they should be doing best, which is to build their own individual economies in a way which will then have spill on and significant other value to the overall economy. And those persons who hear me all the time know that I'm a leveraging person. I speak always about how dispute management options can be leveraged in support of personal growth and development and overall economic stability development and so on. I think mediation is capable of doing that much better, certainly at this time, than would litigation, arbitration, adjudication, or any of those other processes. So that is what I would say about how it is. It's a question of how you construe it. It's a question of how best you use it. And it also requires that the mediators who are getting involved are sensitive enough, because that's a critical factor, to the need for enabling the parties to understand the value of distribution of losses.
Indeed, indeed. Well, everyone, I would just like to thank you for your participation this morning. I am getting the signal that we have to move on to the next panel at this time, but I would just like to thank you once again. Your views were very informative, and we look forward to your participation at next year's summit. Thank you all very much.
Thank you, Colin. Bye-bye.
Thank you.
Thank you. Hi, Peter.
Thanks, you guys.
Thank you. Yes, thank you very much.
Jeanette.
All right.
Okay.
Thank you
Bye-bye.
so much.
Yeah.